Okay, calling case number 11, the final case on our docket this morning. Case number 363414, Scio Township Clerk versus Scio Township Board. Good afternoon now, and may it please the court, you can lower that down if you want, or the whole podium. Thank you. Last appellant was quite a bit taller than me. Yeah, I think taller.
And then everyone else who spoke before.
Yeah. May it please the court. My name is Mark Magyar. I represent the Scio Township Clerk. The clerk is in the courtroom today. The resolutions that the board passed that are at issue in this case, and then the subsequent actions that the board took under the authority of those resolutions, interfered with the clerk's statutory duties under MCL 41.65. And in that way, they violated Michigan constitutional and statutory law. And therefore, the clerk is asking that those resolutions, those and really any, because, you know, there's been more activity in the township since then that has not changed where we're at today. That the custody that the clerk has by law must be restored and those resolutions vacated so that her duties are not interfered with. And I couldn't help but note in the last argument that there was a separation of powers issue. And in a different context, there is here too. The big problem and the reason the clerk felt compelled to defend her office was because, and you know, we've gotten into the Plant Moran and different things, but the separation of powers is not separated anymore in Scio Township. And you've got people that handle cash that are now being allowed to make entries to the general ledger. And there really isn't any way, in our opinion, to read the statutory law without concluding that that is an interference and a usurpation of the clerk's exclusive statutory duties. Now,
the problem, and correct me if I'm wrong, but the problem with these resolutions was it gave, I don't remember if it was a supervisor and the deputy supervisor, but other persons other than your client access, and I think it's on the computer, right?
Yes.
It's computer access to records.
Yes.
And the concern is that they can be manipulated, whatever.
Yes.
Does that, because the statute says that the township clerk has custody of all the records. Well, if the township clerk is not limited in her access, and I guess my thing is she still has the ability to. She can't control who has access to it under these resolutions, but she can. And this is more of a question. She can determine who else has had access and what they've done to the records. That's not possible?
No, I mean, in some cases it may be possible, but the problem is that in some cases it's not. And what we saw in May 2022, where it really came to a head, and when we saw the resolutions put in action of what they actually permit to happen, which was that an interim employee of the board, not a trustee, not an officer, an interim employee had the highest level of permissions to the point that he removed completely the clerk's access and gave access to the deputy treasurer, who was also serving as the deputy supervisor. There were 155 journal entries made by this employee without any visibility to the clerk. And
do you read the statute to say that the clerk has exclusive custody?
Yes.
And like she's the gatekeeper for the records, or as long as she has full access to the records, then if other people get it, that's not prohibited by the statute?
It is prohibited. And the reason is that sort of separation of powers. If someone can at any time, which is the current state of affairs, change the access, take it back to no access, move access, then the clerk is now being interfered with and not able to exercise her statutory duties, because really it becomes at the whim of who has these authorities.
But I guess I'm trying to think of an analogy to the world that used to exist where everything was in paper.
Right.
The clerk has custody, like in the circuit court. The circuit court clerk has custody of the records, but anyone can go down there and look at the records, right?
Yes.
So if you got a declaration that says essentially that the statute requires that the township clerk have full access and custody of the records, but not exclusive custody, how is that inconsistent with the statute?
Well, it is inconsistent, and
It is or is not?
it is
How
inconsistent.
is that?
Yeah. So, and I like you, Judge Murray, had to liken it to hard copies when meeting with my client and making these arguments. And think of if they were hard copies and they were in a safe, that you go from only the clerk having the key, which certainly she can get them out, she can give copies to people. What these did was give the key to another key, a copied key, to an employee of the board, and in some instances took the clerk's key away, and then at their whim, because it's not exclusive, can give the key back whenever they want or take it away. Now, to directly address your question, I did want to focus on the law today because the facts are not in dispute. I think the first place to look is the Michigan Constitution, Article 7, Section 18, where it says that the clerk, treasurer, supervisor, the trustees, that their legislative and administrative powers and duties shall be provided by law. So the Constitution creates these positions and then says you have to then provide the duties by law. And we have those throughout MCL 4165, and notably the treasurer and the supervisor have their own duties under 4162. MCL 4162 is the supervisor. I mean, I don't think the board's going to contend that anyone besides the supervisor should have, for instance, access to the assessment rolls. That's exclusively the domain of the supervisor. Same with the treasurer under MCL 4178. So I don't think anyone's going to argue, the board's going to argue that anyone but the treasurer should have the exclusive responsibility of the accurate account of the receipts and expenditures of township money in a book or by electronic means. And each of these statutes discusses, especially the clerk's duties under MCL 4165, that all of those duties and the things that the clerk shall do are except when otherwise provided by law. So if it's not otherwise provided by law, it has to be exclusive. And if it is otherwise provided by law, it is not exclusive. Such as the ones I just mentioned where the supervisor has certain books and papers, and so does the treasurer. As we've briefed, the clerk had to set a bond, and this is another.
Is the adoption of a resolution, would that be considered a law in Scio Township?
Well, I think if what the resolution does is permits the board to then interfere with statutory duties, that's what the McKim case
But
said.
looking at MCL 4165, it says that shall have custody of all books, records, books, and papers of the township when no other provision for custody is made by law.
Right.
So if the resolution's law, there's another provision made by law, isn't there?
I don't think a board resolution is a law. And if that's the case.
That's my question.
No, it isn't. And the reason it
And why
isn't
not?
is because any township could usurp the Michigan statute, the legislator, or the Michigan Constitution.
But
If
it
they-
doesn't specify whose law in the statute. It just says by law. It doesn't say it has to be a law that this legislature passes. It just says law.
Well, candidly, Your Honor, I'm not aware of what would make a resolution a law. So I respectfully don't.
That's why I asked.
Yeah. I don't think it is a law. No, it's, this is where, the board and the circuit court agreed that they didn't even want to address the issue from a jurisdiction standpoint because they thought it was a policy dispute. I think resolutions are policy, but where you tip the scale to having.
Law is the institution of policy, isn't it?
Yeah, I suppose that's true. I don't think resolutions though could be, I mean, what is the consequence of violating a township resolution? I mean, I don't know that it has the legal effect of violating a statute or a constitution. But did I answer your question?
Yeah, that's fine.
Because I did want to touch on MCL 4169, which is where the clerk has to give a bond, and it says it's conditioned for the faithful discharge of the duties of the office. So this is again a reference to MCL 4165, that the clerk has the duties of the clerk's office according to law. It says in the statute, duties of the office according to law, and including, quote, the safekeeping of the records, books, and papers of the township in the manner required by law. And as the McKim court, and as we've briefed, I know McKim is prior to 1990, and we are asking that it be reaffirmed in this case. But the McKim court looked at this provision specifically and said, if you are putting up a bond and you're charged with the custody, you can't be fulfilling your duties if other people can invade those duties. And we respectfully submit that McKim decision was soundly reasoned and should be reaffirmed under MCR 7.215B4. There's also, the treasurer has a bond requirement also, but also MCL 4175A is another provision where we see this exclusiveness concept in the statute, because that says, and now we're specifically talking about the township administrator, or as the statute refers to as township manager, but they're the same thing, that when the board employs the manager serves at the pleasure of the board and shall perform duties lawfully directed by the board, except those duties that are delegated by law to another township official, unless the consent has been granted. That's MCL 4175A. So what would be the point if we're not talking about exclusive duties of saying that you can have the township manager do whatever you want as long as they're not duties that are already delegated? The clerk clearly has the duties delegated under MCL 4165, unless consent has been granted, which the clerk has never done. Why would the clerk have to give consent if accepting the position that it's anything but exclusive rights and duties under the statute? So far we've talked about the Constitution and statutes. There are a couple of other authorities to look to. For one, before we get to the case law, we've cited the Kenneth Verberg treatise. I would note that the Michigan Township Association recognizes Kenneth Verberg as an expert in this field. I know it's clearly a treatise is not binding, but this isn't just any sort of treatise. This is kind of like the manual for township governance, and he has a chapter called Protection of Treasurers and Clerks, where he talks about that. Yeah, this is political. They're elected officials. They're fair game in the political arena, but not to the point that these officials cannot carry out their statutory responsibilities. And I think that's consistent with what McKim held. We also, I'll just rattle through them. They're in our brief. I know we don't typically just come up here and recite our brief, but there were 4 attorney opinions and an auditor opinion that are in the appendix, all of which said nobody should be allowed other than the clerk to make like write over changes, basically manipulate, not in a derogatory term, but change the records. And even counsel that's going to argue today provided one of those opinions to the board, saying that if you have information that you want to put in the ledger, that it should be passed on to the clerk. But that's not what's happening in Scio Township, and that's not what happened as the impetus for the First Amendment complaint. For 2 years running, including most recently, Plant Moran has found this to be a material weakness in internal controls, that people that can deal with the cash can also make entries. There is, besides McKim, there's a 2006 case that factually it's not really on point. It's Grabow versus Macomb Township, 270 Mishap 222, with a pinpoint site of 231. But in a published opinion in 2006, this court did acknowledge that, quote, township clerks are elected officials subject to duties imposed by law. That court quoted the constitutional provision that I've already discussed. And that court said the township clerk has duties prescribed by law and cited MCL 4165. So I think that's a more recent acknowledgement of the duties that are bestowed upon by law as the Constitution.
Well, there's no question she has those duties. The question is it exclusive? That's the question.
Right, and respectfully, Your Honor, I think this entire scheme doesn't work if it's not exclusive. It's the whole point is that, as we talked about with separation of powers.
Yeah, you've made that argument with all the different statutory provisions.
And I'm not going to. There was a lot of briefing on it, but that's the conclusion that the McKim court came to that I thought was well reasoned. And I want to, again, I mean, I appreciate the questions about exclusivity, but
that's the issue.
Exclusive, but until this change, that's how it's always been, and that's where it is everywhere. And if we think about
that might be how it's always been, where it's
because it's the law.
That's the way that people have read the law. Is it actually, does that make it right, or does that make it the proper statutory interpretation?
I believe so. Based on the language of the statute, I believe that the McKim's interpretation was absolutely correct. And that to interpret it as the board would, and to not have conclusive and have what they've called concurrent well, I've made the argument. And some of the implications of this are huge. I mean, if that townships all over Michigan get a copy of this opinion, if it goes in favor of the board, and say, well, now we can kind of shuffle around, MCL 4165 is aspirational. It's not required. Again, I would liken it back to the supervisor's duty. Are we going to say then that any township can pass a resolution that assessment roles aren't exclusively with the supervisor? And another thing, I don't want to sort of fall into what happened in the circuit court as well, when we got so focused on the word custody that we didn't look at the rest of the statute, because it has a lot of responsibilities and a lot of duties of the clerk, including that the clerk shall be the one preparing the general ledger. And we know that at least for a blip in time, in order to sort of backdate and hit hit the audit requirements, that the clerk was shut out of that.
I think we understand your argument.
Okay, thank you.
Any questions? Okay.
No.
We have a few minutes for rebuttal.
Thank you.
Afternoon, Your Honor. Mike Homier on behalf of the Scio Township Board. I want to correct a lot of misstatements, and I think these come from lack of counsel's knowledge about municipal law and how it works. The clerk's custody of public records, the township's records, the public records has never been exclusive, not ever. And the reason for that is because public records are kept where they're kept. So for example, I can guarantee you there are public records at the fire department. The clerk's not at the fire department. She may have the duty still for safekeeping of those documents, but they are not exclusive. Firemen have access to them. Fire chief has access to them. Similarly, utility departments, utility records, public records, right? Utility people, DPW people, they have records. They have access to those records. It's never been exclusive. To deem it to be exclusive would create a nightmare for responding to FOIA requests, for example. Similarly, those documents have to be made available to other township staff. Why? Well, because, for instance,
Why would it, like, wouldn't, when you brought up the example of a FOIA request, wouldn't the clerk just designate a FOIA coordinator and then that FOIA coordinator would have access to all the records? I mean, this seems to be what was done here. It seems to be subverting the statute that says that she has custody over the stuff if somebody is allowed to go into those records and modify them.
well, so let's talk about the modification that occurred. The reason why that occurred was the audit was going to be delayed yet again. That was a problem. And so what happened was they had a township manager who was trying to allocate resources in order to get that job done. There were alternative proposals that were put out by the prior manager. When council talks about an interim employee, that employee was the township assessor, had been an employee for 43 years, had been brought back in an interim capacity. And by the way, he had this quote unquote enterprise access to BSNA, which is just a fancy term to say administrative access, as opposed to say access to particular parts of this BSNA. But in getting to the point, there was a point in time where the administrator, the interim administrator, gave read-write access to an employee to assist with the reconciliations. When I was asked about it, I said, well, to the extent then that clerk is objecting to that, then make it just read access. That way you could still come up with those reconciliations, hand those off, and they could still be posted. So that was a period of time, about 11 days, I believe. Okay. Where then that was changed back to just read access only. By the way, it's not as if, and I don't want to give you the wrong impression, it isn't as if the clerk is actually doing this work. There is staff that does all this work. In fact, the clerk at some point said, well, I can't.
Under the direction of the clerk.
Well, depends who you ask, because the statute doesn't allow the clerk to hire staff. That's how this all got started. The clerk asked the circuit court to give her sole authority to hire employees, but that's not provided by statute. There's one person the clerk gets to hire, actually engage, and that is the deputy clerk. And then the with regard to the compensation, that's still determined by the board. So this is, and this gets to my larger point, this has always been a political dispute from the start. And the reason for that, and I'm not suggesting the policies are right, wrong, or otherwise.
Well, we don't really care about the political dispute. We got to look at the statute. What is it? Does it mean exclusive or not?
So
That's the issue before us.
So, you know, the plaintiff relies heavily on McKim and says, oh yeah, it's exclusive. But if you actually read McKim cites to, and presumably with approval, to the lower court. And that's under head note 2. And it says, We also agree with the trial court that defendant's 18-hour restriction constitutes an impermissible restraint on plaintiff's authority as township clerk. In regard to this restriction, the trial court stated, there are many statutes outlining the right of the public to access to township records during normal business hours. And indeed, clearly, the township clerk must not only make such documents available to the public, but also to other township officials.
Does McKim say exclusive control?
No.
All right.
It does not. And that's the difference here. What we're talking about, McKim says you can't prohibit the access of the clerk to those records.
Is that done by any of these resolutions?
No, none of them. In fact, the clerk had access to all the records, custody at all times. I'll give you an example of custody, and you may think that it's a little off base, but I think it kind of shows how this works. If my 9-year-old daughter goes down to play at a friend's house, I haven't lost custody. It's just located there. I still have care, control, right?
Yeah, but what if when your 9-year-old goes down to the friend's house and they cut her hair, then they've altered that, and you know, that's the thing that's at least bothering me, is that if a statute says a township clerk has custody of these papers, how is that effective if the township board can just say, well, you get to get in there and change these records, and you get to do this and you get to do that. I've lost control and I've lost custody over those records as the township clerk, haven't I?
I don't think so, but more to the point, that's not what happened. What happened was these resolutions were adopting job descriptions. The job descriptions, unremarkably, told the manager you should manage the day-to-day operation, including access to the township software. And I'll tell you where this was revealed simply as politics is, and this is included in their brief, the clerk doesn't mind having a third-party IT vendor have that access. It's only these people she doesn't want to have that access. Now, what happened was, once they had access, trying to get the reconciliations done, as soon as she objected or very close thereto, they withdrew that write access and now gave read access only. And that has been the case ever since. Nobody has gone in and changed one single record without the clerk's knowledge or consent, because then they hired an accountant to help with those reconciliations who had access. They've hired other staff since then who have access, all of which presumably was consensual. So we're talking about 11 days, which is why we raised the mootness issue. The enterprise access has been restored. There is nothing to litigate here any longer. There just isn't.
Appellate's counsel makes a pretty good point. I think he said every clerk in this state has exclusive access, but for Scio Township. Is that true?
No, it's never been true. Go to any municipality. I've been practicing municipal law for 25 years. I have hundreds of municipal clients across the state. It has never been exclusive. There are times, for example, there is a duty to prepare and maintain the journals and ledgers. That was never, ever affected by this, not one time. In fact, when it was,
I'm sorry, go ahead.
when it was brought to the attention of the interim administrator, we immediately said to him, that's fine. Apparently she doesn't want that help. Withdraw the write access, read access only, which is perfectly legitimate. Otherwise, in some instances, departments cannot function between themselves if you said, I'll put it the other way around. Let's suppose that the clerk says, I have exclusive access. I know you, township supervisor, you're charged with preparation of the budget. I'm not giving you any financial information. Well, now what? Right? And that's why it's never been exclusive.
But is that right? I get that part, but I guess is it exclusive in the sense that obviously people have access to the records, but who? In other words, isn't the township clerk like the gatekeeper for the records? Like if you said someone has a FOIA request, well, the FOIA coordinator on behalf of the clerk deals with it. If a police officer in the township wants to amend a police report, he can take his amendment, give it to the clerk, who can attach it to the record. I mean, assuming this was on paper, but the point is doesn't the statute give the township clerk the gatekeeping function? And was that taken away by these resolutions that said, even if it was for 11 days, these other people can go in there and change the records?
Except that that's not what the resolutions did. The resolution set job description, including management of the township software. I mean, they're part of the record. You can look at the job description, but even the statute says that the township clerk shall have custody of all the records, right? So if you deem that to be exclusive, then I'll give you an example. Those public records down at the fire department, they're going in and out every day, right? So they might even have, in some cases, depending on the municipality, they may have multiple FOIA coordinators, one for each agency, right? So the clerk is not exercising exclusive jurisdiction over those documents to say yes, no, right? That's just a function of public records. Now, I do agree with you that in the broader scope of the statute, right, it is her duty to safeguard those records, but that does not mean exclusive. So the township has never excluded the clerk from any access to any record. I want to make that clear. Your point, Judge Murray, is that, that care and safekeeping is degraded if other people go in and change, okay? So if you have those other people working in finance staff and doing that, at least to my knowledge today, all of that has been resolved, that there are no changes going on that haven't been consented to. There may be access to those, but take like the supervisor's role, which counsel says, well, that special assessment role is exclusive jurisdiction of the supervisor. Well, in what sense, right? Because they share those with the property record people. Why? Because we're tracking splits, making adjustments, et cetera. It's never been deemed exclusive. And for all intents and purposes, these are the public's records, right? I agree with you that we can't, in order to safeguard those, you have to limit those changes. And that's why, to my knowledge, those were changed back to read access only in order to still get that audit done. So I don't think that there's anything left here. And I don't think, for that matter, that the court should step in and run the business of the township, particularly when, except for maybe those 11 days. And by the way, all of those were restored. And then you know what happened? They were all redone. So again, this is a control issue, nothing more than a political dispute that should have no place in the judiciary, frankly. And we started this case out by the clerk suggesting that she had exclusive authority to hire finance staff. That's simply not true. There's no basis for that.
I think we understand your argument.
All right.
Thank you.
Thank you.
You have a few minutes for rebuttal, Mr. Magyar.
Thank you. I think it's my turn to clear up some misstatements. First of all,
Take a few minutes to do that, but not a lot of time.
Yeah, I don't have a lack of knowledge in municipal law. I have a public administration degree. I grew up with my dad being an attorney for 2 townships. I can speak just as well as Mr. Homer on these issues.
Well, it really doesn't matter what either one of you says. It really matters what the law is.
Right.
Yeah, we don't care what
Well,
you guys.
Don't worry about what he said
Yeah,
about.
we don't care what you guys say about each other. Just
Right.
don't fight outside the courtroom. All we care about is what the law says, and to tackle Judge Murray.
You asked if McKim uses the word exclusive. What McKim says is that the statute bestows a township clerk with the responsibility to exercise control over all township papers unless otherwise provided by law. So I will grant that it
Then
doesn't
we
say.
go back, and my question is a resolution law.
And you heard Mr. Homer say that it was a job description. So even more so that I don't think it could be a law. But the problem with it being just a job description is that it was that job description that they called up the IT vendor to say, this is what permits us to change the permissions. And I need to clear up a misstatement because it was in their brief and it was said again here. The clerk has never been restored to top level enterprise administrator. That's not true. We looked at the system again on December 5th, 2 days ago. She has administrator, which many other people have as well. There is currently nothing preventing the board from doing the exact same thing. Mr. Homier admits that there was 11 days of a flurry of journal entries to the exclusion of the clerk. And under the current system, there is nothing preventing that from happening at any time again.
Okay.
And the last thing I just want to say is I agree. I think the exclusive question was being blurred. I agree with Judge Murray's statement about gatekeeper. The fact that the clerk can have exclusive custody, but then provide access to anybody is of course true. And it happens all the time. This isn't us saying we want the clerk to just squirrel them away and nobody can ever look at them. So all this stuff about the fire department and I mean, that really doesn't move the needle because there's still a gatekeeper. That's what we're talking about with exclusiveness.
Any other questions? Thank you. That's it. The case is submitted. That concludes our case call for today. We'll be back tomorrow at the same time.
How did Pegasus Wind go yesterday?